Welcome to AlteaTalks, the brand new podcast series being brought to you by Altea, the unique provider of combined insurance and risk management solutions designed exclusively for the medical, allied health and care sectors. I'm going to be your host, Will Marshall, and I'll be joined in this series by some of the leading movers and shakers from across the sectors. My guests are going to include practitioners and professionals, regulators, clinical risk and governance specialists, and an array of legal experts who are going to help us get to the heart of the hottest topics affecting the UK's health and social care sectors today. So, if you're looking for frontline knowledge and expertise, if you want valued insights into these most dynamic, challenging and rewarding of sectors, then look no further because you're in the right place. Welcome again to AlteaTalks. Hello and welcome to this latest episode of AlteaTalks. In this week's episode, I'm delighted to be joined by Victoria Heyworth and Arya Tabrizi. Victoria and Arya are both practicing barristers based at King's Chambers in Manchester. King's is a leading set of civil law barristers. It's ranked as one of the country's leading sets, providing barristers with the highest reputation in their fields of expertise. Victoria is nationally recognised as a leading clinical negligence barrister. She has a huge amount of experience in a wide spectrum of clinical negligence work, including cases involving midwives, surgeons, optometrists, dentists, GPs, nurses, and care workers. Victoria has acted for a very wide range of clients on both sides of the litigation divide, including private individuals, NHS trusts, medical defence organisations, and private medical and related institutions and their insurers. Arya is a more recent member of the bar, but he has already gained significant experience in working on high-value and complicated serious injury work. This includes a variety of clinical negligence work, industrial disease work, claims under the Fatal Accidents and Law Reform Acts, occupiers and employers' liability claims, as well as cases with a human rights element. In today's episode, we're going to be discussing some of the key issues and themes shaping clinical negligence cases today. And I'm going to be inviting Victoria and Arya to share what they're seeing on a day-to-day basis at the very sharp end of the process. As practicing barristers, both of my guests today regularly appear before judges in courts up and down the country, meaning that they are uniquely placed to provide valuable insight into how some of the key medico-legal issues that give rise to claims, such as consent, record-keeping, and vicarious liability, play out when they come under the microscopic forensic scrutiny of a courtroom. Victoria and Arya, welcome to AlteaTalks.
Thanks very much. Thanks for having us. It's really great to see you and to talk about these topics.
Yeah, thank you, Will, for that lovely intro.
It's an absolute pleasure, and thanks again to both of you for agreeing to take part in today's episode. So let's start at the top, as it were. The impression, certainly, that many people have had in recent years is that the Supreme Court and Court of Appeal decisions in the clinical negligence sphere have becoming more favourable to healthcare defendants than to claimants, and that there has been a tightening of the law on certain key issues such as consent, duty of care, and most recently with regards to secondary victim claims in the case of Paul in January this year. Vicky, can I ask you, does that general impression of a more favourable Supreme Court attitude to healthcare defendants accord with your take on what's been going on at the top? And also, can you tell us a little bit about the Paul decision in particular and how the law has changed regarding secondary victim claims?
Yes, so I definitely would say that they are keeping us on our toes, and there was quite a lot of surprise in relation to the outcome in Paul and Wolverhampton. Background to it was that certainly one of the claims was a gentleman who'd had investigations for potential cardiac issues. Those had not been of fruition. several months later, he was out shopping with his 2 daughters when he had a significant heart attack and unfortunately passed away in front of them. The questions really were surrounding when you have a breach of duty, which is separated in time from the ultimate consequence of that breach of duty. And that was considered at length. Ultimately, the court made the decision that in order to succeed with a secondary victim claim, the claimant would need to witness a traumatic external event or the immediate aftermath and would have to have a close tie of love and affection with the person who passed away or suffered the traumatic event. And that's been broadly considered to be a huge restriction on the ability to claim for a secondary victim claim, more or less wiping it out in a clinical negligence setting. So yes, I would say looking at that judgment, that you could argue that the tide has turned perhaps from previously more sympathetic claimant decisions towards a stricter application of the law.
Yes, thank you. And Arya, maybe if I could ask you about the other big Supreme Court decision in our world in the last 12 months in the case of McCulloch about consent, and maybe ask you the same thing, whether you see that as a further example of a more defendant-friendly Supreme Court tightening the law, or whether it's actually something different from that.
Yes, well, it's interesting what Vicky quite rightly said about Paul being really quite a big surprise to most practitioners at the time, and especially in how conclusive it was. It has all but ended secondary victim claims in a clinical negligence setting. McCulloch was perhaps more of a clarification, a welcome clarification nonetheless, and a healthcare practitioner-friendly clarification, but a clarification surrounding the law regarding informed consent. And a lot of the listeners will be familiar with the leading case on informed consent, which is, of course, Montgomery. Montgomery very briefly tells us 2 things. You have to tell a patient of the material risks of any particular treatment course, and you also have to inform them about any reasonable alternative treatments. McCulloch clarified what tests apply to what branch. So whilst Montgomery is still good law and you still have to inform a patient of those 2 things, significant risks, reasonable alternatives, what constitutes a reasonable alternative so far as treatment is concerned is still a matter of clinical judgment. And as such, it is subject to the Bolam test. So practically speaking, if you consider as the clinician in charge of an individual, a patient, that a particular treatment is not a reasonable alternative, and of course all of these decisions are multifactorial, and a reasonable body of practitioners would support you in saying that it wasn't a reasonable alternative, you don't have to disclose that to the patient, notwithstanding the fact that there may be a different body of practitioners who might have done so in those circumstances. And that, if anyone thinks about it for longer than 10 minutes, is of course entirely logical and a welcome clarification.
To what extent have we seen them, or have you seen the McCulloch decision being applied in practice, either of you, since that decision was handed down?
I had a trial actually in January where that came up and was one of the issues in dispute. Not got judgment yet. Watch this space. But it was one of a number of different things that came up. And when the judgment came out, I myself was, on the phone to certain solicitors over cases that I had in mind to say, go back, look at the pleadings, let's reconsider this. Do we need to amend? Do we need an additional question in the agendas? How are we going to approach this? I personally think it's made a big difference, and it has made it much more difficult for claimants to bring claims in relation to consent. Ultimately, I think, though, it is a common sense approach. I would say that, wouldn't I, in this podcast? But I do think it is a common sense approach. And I have had those discussions before that case came out of, where are we really going with this? What is the word reasonable? So I agree with Arya in that respect. It's a welcome clarification. At least brings clarity for everybody as to where the line's drawn. It was, of course, preluded by Bilal and St. George's.
Yes.
But that didn't really give you a huge amount of information about it. It was just kind of mentioned towards the end of the judgment and sort of thrown in there as a bit of an extra. So I definitely think McCulloch has been a welcome clarification of that issue that's been bounced around for a while.
Yes, thank you. And in the light of that decision, Would there be anything that either of you would be suggesting that practitioners might be looking to do in their daily practice to help to protect themselves in the event of a claim with a consent issue in it being made against them?
I think similar things to what you were discussing with Vicky on the consent podcast, really. Certainly the issue is out there as to whether or not, if you as a practitioner don't offer an opportunity or a treatment option, whether or not you should raise that. And it's certainly food for thought. I think in terms of consent options, my view is often that in notes, the words are written consent discussed, but the actual context or what was involved in that discussion is very rarely written down. So we'll come on to that, I guess, in due course in terms of record keeping. But I think it's probably more about, when you're at school and your teacher says, but how did you get to the answer to that maths question? Where's your working out?
Show you're working.
Yeah, I think it's definitely that. You need to show you're working.
Yeah, we will come back to that. Sorry, I took that one a little bit out of turn, so apologies for that. But in terms of the other broader themes that you're seeing currently in clinical negligence cases, I know that we are now seeing a lot more publicity from about indemnity organisations wanting to take a harder line on cases where they think the claimant has either been dishonest or has exaggerated their claim. Is that something that you're seeing and that is happening?
Yes, certainly from my perspective, having done this work for a while now, in terms of fundamental dishonesty, I do think that over that time, insurers have become much more au fait with the issues of fundamental dishonesty. When I first started, I think that there was a reluctance out there to raise those issues, particularly in clinical negligence cases. Having started off in the personal injury arena, I was quite used to those issues being bounced around, rolling up your sleeves and getting in there. But certainly in clinical negligence, it took a while for that to really come through. But I think more and more so, organisations are stepping back a little and thinking, what's going on here a little bit more, and perhaps being a little bit more critical with their eye over what's being said about the issues that individuals have. So in terms of examples, there are quite a few interesting ones. You obviously got the Calderdale and Huddersfield versus Metcalfe case, where in actual fact, the claimant at the 11th hour admitted that she had made dishonest claims, and there were considerations in relation to committal proceedings there. There's Idion and Warner in 2021, which was in our Manchester County Court, actually, with Judge Sefton QC. That was an admission of a breach of duty from a lady who had breast cancer, so it wasn't picked up sufficiently quickly. She alleged that she had ongoing serious chest pain as a result of the mastectomy that she had ultimately in the treatment of that cancer, and she was noted to be partaking in various races and timed running events and other sporting events. Ultimately, she was found to be fundamentally dishonest in relation to that one. You've also got the case of Kajanu and Essex, slightly unusual one, where the claimant suffered an injury to his hand during the course of murdering his wife. And whilst he was in prison, there was issues over the treatment of those injuries to his hand. He had alleged that those injuries had been sustained when protecting himself from his wife, but actually it was the other way around. And in that case, he was found to have been fundamentally dishonest. More recently, you've got the personal injury claim. So it's not quite the clinical negligence context, but it's quite a biggie because it was for $600,000 or thereabouts, where a lady called Miss Williams-Henry was found to have made dishonest claims in relation to a brain injury she sustained when she fell off a pier looking at bioluminescence in a harbour. So all kinds of unusual scenarios in which fundamental dishonesty has come to light. And I would say there's certainly more of a confidence from indemnifiers to bring or to raise those issues.
And in those cases, the damages awards the claimants received, the claimants who've been found to be fundamentally dishonest, what happened to those damages?
So in relation to the Williams-Henry case, the judge, as is required, assessed what damages she would have got had she not have been found to be fundamentally dishonest. She wasn't awarded those, but she was allowed to keep an interim payment of about $75,000, I think it was, essentially because she didn't have the funds to pay it back.
And that's not where the story ends for some of these claimants, is it, Arya?
No, that's right. It's interesting coming in perhaps slightly later in the FD timeline. Sorry, Vicky. But seeing the difference between PI and ClinNeg and the way they pursue fundamental dishonesty, it seems to me now organisations like NHSR are perfectly well versed and perfectly proficient at obtaining sufficient evidence to allege something like fundamental dishonesty. And it's worth remembering at this point that you do need cogent evidence to make that allegation because it is essentially a species of fraud. But that evidence seems to often be used to simply make what's called a drop hands offer. So instead of using that evidence to go ahead and either plead or make a submission on fundamental dishonesty at trial, and of course in doing that then pursue the various repercussions and remedies that are available to the defendant once that's been found, instead it's used as a stick to say to the claimant, well, hang on, if we do go to trial, that's what we will do, but why don't we all just walk away and not think anything of it from this point onwards? That attitude does seem to be shifting slightly. After waiting a while, we've had 2 or 3 judgments in relation to pursuing fundamental dishonesty repercussions through the courts. There was one, by way of example, in 2022 in the High Court, North Bristol NHS Trust and White. This is a high-value Cauda Equina case. Liability had been settled on a 50-50 basis. There'd been 3 interim payments of $45,000, totaling $45,000. But the schedule of loss was pleaded at some $4.1 million. As with all Cauda Equina cases that are pleaded at that amount, you can imagine what the claimant's assertions were in relation to her capacity to do any part of her life, really. However, Taylor's oldest time, the defending trust, in October 2018, obtained surveillance evidence showing the claimant performing various day-to-day activities, and it became apparent from the video evidence that the claimant's complaints to her own medical experts was far from the truth and in fact downright dishonest. The trust disclosed the videos and invited the claimant to withdraw from the claim with no order as to costs. Interestingly, she declined. So that goes again to the point made earlier, that it's often used as a stick to say to the claimant, well, let's all walk away and not think anything of it. For reasons unbeknownst to anyone other than perhaps herself, the claimant declined that offer, even when faced with the video footage. It was at that point then that the trust pursued fundamental dishonesty and the full repercussions of such. You've heard from Vicky what the cost implications can be. And of course, whether you actually recover those costs is another thing entirely, but it acts as a disincentive. But perhaps the greater disincentive is that, of course, you can be held in contempt of court. Mm-hmm. And in that case, the claimant was sentenced to a 6-month custodial stint for contempt of court. And the court decided, after hearing various pleas in mitigation from counsel, not to suspend that sentence. So she did actually end up serving time in prison.
And she had a young child, didn't she, as well, and certain sort of domestic difficulties, but the court took the view that it was sufficiently serious that she should go down.
That's absolutely correct. And in the judgment, the court did air consideration of both the claimant and her son's Article 8 rights. But as you said, it was considered sufficiently serious for her to serve time in prison nonetheless. And that is an unfortunate series of events, but hopefully a marker and a disincentive for conducting claims of that value in that way.
Yeah, thank you. And just staying on the topic of broad themes that we're seeing at the moment, Vicky, I know that you've got a bit of a bee in your bonnet about the number of law firms that are new entrants into the ClinNeg market, and we're seeing a proliferation of law firms sort of testing the water, as it were. What's your experience about that?
Yeah, I would definitely agree with that. I don't know if it's a coincidence that the personal injury market is getting a much less comfortable place to be, but certainly in the last, I would say, 5 years or so, there's definitely been an uptick in strange claims or claims brought in a strange way by perhaps people who don't have the experience in clin-neg work and are transferring their skills over from PI. There are a lot of similarities, obviously, but I do think you can see it quite clearly when that's occurring. There are those little nuances, like individual pleadings of causation and other issues over your condition and prognosis evidence, or when your breach of duty evidence should be exchanged. So it is quite clear, and it does make it sort of quite tricky sometimes to deal with. I don't know what your experience is, Arya, but in terms of those, so for example, those fundamental dishonesty cases, you're much more likely to have those kinds of issues. Obviously, not always, but I do think you are more likely to have those kinds of issues where you have someone with inexperience on the other side for whatever reason dealing with. Is that your experience, Arya?
Yes, certainly. And it's worth remembering, of course, that it's almost always no answer for the claimant to turn around and say, well, that was on my solicitor. You will sign your own pleadings and you'll sign your own witness statement. And if you're not properly advised, it can lead to you signing off on things, let's say a schedule of loss in relation to fundamental dishonesty that isn't properly evidenced. And in clinical negligence claims where causation can be significantly trickier than your standard personal injury, certainly, that can lead to real difficulties. But obviously from a defendant point of view, it's worth identifying those claims because it will often provide you with an opportunity to defend on perhaps several fronts where you might not have had that otherwise if it was properly pleaded.
Yeah. And I think in many ways, it's a kind of irony, really, that sometimes, tactically speaking, it works to the advantage of the individual without the experience because it's not nailed down in the same way as perhaps someone with experience would. And you're more likely to end up at a trial as well, I would say, because the risk is perhaps not quite so evident to the parties on the other side in order for them to really take stock. So you find them running issues that otherwise would have been dead in the water a long time ago. So, yeah, certainly I do think there is more of that coming on into the market. And my view is always to grasp the nettle early and to clarify and to, if needed, actually assist and point in the right direction so that everybody knows what they're talking about, because clarity can only ever assist parties in actually narrowing the issues and getting to the root of the problem.
I think that's a really good point about cases going to trial more often because of inexperience and clarity helping both sides. First of all, let's remember that the longer cases go on, the more costs involved for both sides. That's a particularly pertinent point when you're a defendant organisation, of course. Recently was instructed on a case on behalf of a claimant, but the pleadings by the time they got to me were already served and unfortunately resembled something more akin to what you'd expect for a sort of small claims or fast-track road traffic accident. Incredibly brief and incredibly broad. Now, because of that, the claim had been defended quite robustly by NHSR, and counsel had pleaded a very full and proper defence of the claim on all fronts. We amended the particulars of claim, we narrowed the issues, and the case, I'm told, settled shortly afterwards. Again, if that had been done from the start, the defendant would likely or possibly have avoided incurring costs in pleading the defence, because once you did narrow the issues, it was quite apparent that there was a very narrow claim available.
And one thing that you touched on there was about the signing off of the pleadings, signing the statement of truth at the end of a formal court document or a witness statement. And it never ceased to amaze me, well, on both sides really, but how little care and attention people sometimes pay to those documents, and particularly something like a witness statement, where I think people don't really appreciate that ultimately where this is going, it's going to a courtroom and you're going to be cross-examined in a courtroom on that statement. And I think it's quite helpful to emphasize again the importance to people of really making sure whatever side of the divide they're on, but really making sure that their witness statement or their pleading or whatever it is a completely accurate, full account that they will be prepared to stand by in a courtroom.
I agree. And it's not just limited, actually, I would say, to lay parties. My experience is that most people think trials will settle. From our side of the coin, we see that they don't. And so sometimes even, experts can be upended by arriving in court with their experts' reports perhaps not in the shape that they could otherwise be. And of course, in these kinds of cases, that is a key issue. So I think we can all sit back, can't we, and perhaps take that and consider it at a little bit more length.
Yeah, absolutely.
We touched upon contempt of court in relation to fundamental dishonesty earlier. And with fundamental dishonesty, you often think of claimants, but it's important to remember that contempt of court can be brought against any actor in a litigation or any witness or expert. The rules themselves are termed very broadly, 3114 for any lawyers listening, but proceedings may be brought against a person who makes or causes to be made a false statement in a document verified by a statement of truth without honest belief in its truth. And of course, experts may point, subject to everything that Vicky's just said, of course, but experts may point to information passed on to them as honest belief. But certainly family members who write witness statements, usually in support of quantum claims, can certainly have proceedings brought against them for similar reasons. An example of that recently was Hull University Teaching Hospital in Collie, which was again a 2022 judgment in the High Court relating to contempt of court, but it was the mother of the claimant who'd written the false witness statement, and it was contempt proceedings brought against her.
Interesting. Thank you. I'd just like to move the discussion on a bit, and maybe if we could just have a look at some specific practice areas that our listeners are going to be working in, and just to get the benefit of your wisdom on some of the classic danger areas in those sectors. And if we could start with the aesthetics and beauty sector, what are some of the key issues that you're seeing arising in that space? Maybe, Arya, I could ask you that. And some of the key themes that are coming out in the cases that you're dealing with.
A common theme is the dispute over which pre-action protocol the claim should be brought under, whether that's the pre-action protocol for clinical disputes or public liability disputes. There's no clear authority on which pre-action protocol those types of claims should be brought under at the moment. I've had a couple of cases where I've either defended or brought claims on behalf of claimants. In the claims brought on behalf of claimants, we've always maintained the view that claims against beauticians or for aesthetic treatments are fairly brought under the clinical negligence protocol. And when you look at the current wording of the protocol, it's really quite broad. It states this protocol is intended to apply to all claims against hospitals, GPs, dentists, and other healthcare providers. Well, healthcare providers is the issue because it leaves it open to elective treatment or, for instance, carers in care homes where this dispute is another, where this dispute also surfaces fairly often. That, at the moment, certainly has a big implication as to what cost regime applies. So that's an important issue to be aware of. And from a defendant point of view, it's certainly reasonable to argue that such treatments still fall under public liability and fixed costs.
Yes, because the cost regime under the public liability protocol is more favourable generally to defendants than the cost regime currently under the ClinNeg protocol.
That's correct. Significantly more favourable as it stands, and likely to be, even with current reforms in clinical negligence fixed costs, which I know you've got another podcast on and we'll get into that, but is likely to be significantly more favourable for the foreseeable future. So that's certainly an issue to be aware of.
And that's a decision that is taken or contested at a very early stage of a claim, isn't it? Which protocol applies?
Yes, it's essentially the first step that the claimant representatives will make. And it's the first time that defendants are notified that there is a potential claim. The protocols themselves are important and favour both sides because they set out a series of steps that both sides have to take. And the idea is that they narrow the issues and potentially even avoid litigation, i.e. proceedings being issued in a court altogether. So deciding at a very early point upon first notification of a claim, which protocol you believe from your position the claim rightfully falls under is a key step that will shape not only the next year or two of what you'd call negotiations, I guess, from a lay point of view, but also the litigation itself if proceedings have to be issued.
Yes.
What's your view, Will, about, someone said to me once, if a needle is used and the skin is pierced with the needle, then it's the clin-neg protocol. But before that, it's the public liability protocol. What's your view about that? Do you have one? Do things like that go on in the background, or is it not quite that straightforward?
Well, my approach in the aesthetics cases and beauty cases that I've handled has always been to try and push them down the PL route, mainly because of the cost advantages of doing that. I think my personal view is that if a needle is used, if it's a claim relating to that kind of invasive procedure, and if the purpose of that procedure is essentially therapeutic for whatever reason, then that is a clinical negligence claim. And I don't think you would get very far in arguing otherwise. I always found that the difficulty with is it PL, is it clin-neg, would come when, let's say, you were acting for a care home and a resident is being escorted on a bathroom break and falls. And is that, I mean, that's a slip, that's a trip, that's a PL claim in anyone's book, except that the resident needed to be escorted and had a care assistant or a nurse accompanying them, or didn't. And there's the negligence or alleged negligence. So that I think is quite difficult. But one thing that we try and do, and I think you're seeing it increasingly amongst insurers and for insured clients, is to have more of a one-stop shop for your insurance provider. Now, whilst that's not going to resolve the issues that Arya has been discussing, it does mean that for the provider, whether that's an aesthetics clinic or a care home, if they're going to an insurer that is providing cover for med-mal, for public liability, for employers' liability, in other words, isn't providing siloed cover, but has a comprehensive offering that covers all of those aspects, you don't have the problem where the insured might notify it into their med-mal insurers, who then take a little while and come back to them and say, actually, this is a PL claim, and then have to go and notify it to another insurer. And there may then be a problem because there's been a delay since the incident and before they notify it. So that's one thing that we're certainly seeing on the insurance side of things. And I think the whole aesthetics sector is fascinating at the moment. There is a clear divide down the middle of it between the medics and the non-medics, and medics would include nurses as well, who are in many cases performing the same treatments, providing the same services. But on the one hand, there's a section of the providers who are regulated, whether that's by the GMC or the NMC, obviously have very extensive qualifications and training and experience. And on the other side is a much less qualified, I wouldn't say less experienced, but less qualified side to the sector. And what we're seeing within the sector is really a big public safety movement at the moment. The number of treatments and the number of invasive treatments is growing. We see all the problems around things like Brazilian butt lift and cosmetic tourism going wrong and so on. And we know that a new licensing scheme is coming, but we currently don't know when, and we don't know what that's going to look like. And it's a very, very difficult sector to regulate because it is so dynamic, it's so fluid, and there's such a huge range of treatments and such a huge range of practitioners. So it's an interesting space.
Absolutely. And in terms of where you come at it from your perspective. Do you find there's a lot of anxiety in the industry about what's to come?
I think so. I think there's a consensus that regulation and that the licensing scheme is a good thing and that it is needed and that there needs to be a greater degree of control and protection for the public. This is a hugely expanding industry, and that's not going to change. People who want to have aesthetic treatments and who are having them are becoming younger, and they're having more of them. And I think that there is very much a wish throughout the whole sector to have proper licensing in place. I think where the anxiety lies is that the non-qualified half of the sector is concerned about what that's going to look like in practice, what that's going to cost, because it's not just the practitioners who are going to be licensed, it's also the premises. And I think there is an anxiety about that. But having said that, the government is consulting very widely and it's taking its sweet time in bringing this in. The last thing I heard was it was going to be the end of 2026.
Oh, some time yet to come.
Oh, yeah. Oh, yeah.
That's interesting because in terms of other areas of specific areas of claims, obviously one I work in and Arya does too is the dental side of things. And there has been the relatively recent case of Hughes and Rattan where it was decided that a practice or practice owner owed a non-delegable duty of care to patients who attended for dental work, despite the fact that the individual dentists were self-employed. So it seems to be, whilst we were talking at the outset about a tightening up of the situation that's favourable to defendants, it does seem in other places that the protections for patients are somewhat widening. So in that case, it's been restricted currently to NHS care, and it'd be interesting to see whether or not that applies in a private setting. Clearly, vicarious liability was discounted in that one. And again, interesting to see, I think, whether or not that would apply again across the aesthetics and beauty industry. I don't know what your take is in relation to that, but from my perspective, it does seem to be a protection for claimants in that respect.
Yeah, no, I would agree with that. I think that the whole non-delegable duty, vicarious liability issue is hugely relevant in the independent sector settings that we're working in. And I think that it brings a bit of I wouldn't say a conflict, but it does pull some organizations in different directions because on the one hand, if you're an entity and you're working with a large or a number of individuals on a relatively informal basis, just to sort of facilitate them and to provide them with a platform to do their work from, you want to make sure that there's consistency. But by the same token, you don't want to be taking steps that might give rise to a suggestion or a claim against you on the basis that you've created an employment type situation and exposed yourself to a vicarious liability. And of course, there are ways that you can protect yourself against that to a degree with the contractual indemnities and so on, but you're still exposed to a costs liability if you're brought into a claim that more properly you shouldn't be brought into.
I agree. And it is a bit of a tightrope, isn't it, between that area of establishing some control, but also giving your practitioners the freedom to work as genuinely self-employed practitioners in their space. So interesting to see how that will flow down. I think it has settled down a little bit in terms of in the dental sphere. Certainly at one point there were lots of practices being brought in left, right and centre. And my experience, I don't know about you, Arya, but my experience is that's not quite so much the case now. So perhaps that will happen in the aesthetics industry as well over time.
Well, that's interesting.
I'd agree that it seems to have settled down, certainly from a dental point of view. It will be interesting to see what impact it has on the aesthetics industry. one caveat, vicarious liability just seemed to be so fact specific. It was discounted in Rattan. And of course, dental organizations tend to have more standardized, perhaps more savvy organizations of relationships with contractors or however they're described in the paperwork. But it will be necessary for all clinic type organizations to ensure that, as you said, Will, that they organize themselves to a degree where they can standardize treatment and performance without entering into a set of facts that a court might infer a relationship akin to employment from.
Yeah, thank you. And what else are we seeing in dental space at the moment?
Dental-wise, I would say we've got nerve injuries out of extractions or failure to detect cysts. So those cysts grow and are difficult to remove without a nerve injury. I've seen quite a rise of orthodontic cases, actually, dissatisfaction with the outcome or prolonged treatment. And I think it comes back to the point you made before of actually people are different age groups now when they're getting treatment like orthodontic treatment. And they have different expectations. Also, the classic implant cases, through the sinus or through a nerve. I've not seen as many caries or periodontal disease cases recently, but perhaps that's just a reflection of my practice. The ones I have seen more of maybe are oral cancers and deep infections, which obviously can have catastrophic effects. And if you've got to have radical surgery, can leave long-lasting scarring issues and all sorts of other things, even if life expectancy isn't in the balance. So I would say those principally the ones in relation to dental. I don't know about you, Arya, if you've seen any others.
Yeah, I'd certainly agree. Less caries cases, perhaps an increase in orthodontistry cases. And it's interesting, isn't it, that it's perhaps societal change actually that influences that shift, because people are more aware of what constitutes good oral hygiene themselves these days without being told perhaps by their dentist. And at the same time are electing to have, or an increasing number of people are electing to have braces or something similar. And again, have higher expectations as to the outcome. So it's perhaps driven by external factors as well, which is always something to bear in mind.
Interesting. Can we just move it on now to what advice you would give when it comes to preventing claims? Because we've talked quite a lot about the sorts of claims that you're seeing and what happens when things do go wrong. But obviously, one of the best ways to avoid being in that situation is to prevent the claims from happening in the first place. So, Vicky, I don't know if you would like to talk a little bit about the sorts of clinical behaviours, the sorts of practices that you see that help to prevent claims from being made, or if they are made, make them more easy to defend.
Yeah, I think I'd pick up from the consent talk that you did with Vicky in terms of communication and pressure of time. We're in a world now, aren't we, where communication is by so many different forms: social media, email, obviously talking face to face is the old school way of doing things. But that type of communication now, there's so many of them. I think I said earlier to you, we're so connected, but in many ways so disconnected. So I think I would go back to that and the expectation management. In particular, you've got the aesthetics, but it's not limited to that. But ultimately, it's from the start, considering that patient, their expectations. I think Vicky said on her podcast with you, she'd ask an open question at the start of a consultation. So what are you here for? And I would absolutely endorse that as a way forward. You get to understand then what your client or patient's expectation is, rather than your take on what you think they're in for or what they expect. So I would say that is a really key thing. And that communication, though, goes both ways. So I would say to clinicians, as Vicky did, take the time to consider, does this person need more time to think about what they're going to do? But also, do I need some time to sit back and consider whether this is something that is going to work, or this is something I feel suitably qualified for? Take the time to think about what you're taking on, because at the end of the day, particularly if you're a private provider, that patient has come to you for advice. You don't have to feel pressured into performing a procedure on them if you don't consider that's the best thing for them. So I think that would be my absolute top one, and it is complicated by social media. There are recent cases out there. There's a recent committal proceedings case which is rumbling on over a BBL surgery provider and Instagram posts in relation to that. So we can see how expectations and social media all kind of muddy the waters and bring things into difficult terrain. So I think that would be my number one, is understand what your patient wants, but also understand whether or not you can provide that to them.
Thank you. And Arya, what would be your number one?
Record keeping is perhaps still the surprising one that comes up unfortunately a lot of the time as being inadequate from a defensive point of view. It's amazing actually how many times you look at certain records and think that actually if it was filled out properly or at all, it might avoid the claim entirely. It's often probably best to keep records as if someone else is going to have to read them, not just yourself, because that might just end up being the case. Vicky mentioned it before, but the classic one in relation to consent is consent discussed. That doesn't really take you anywhere when defending a consent claim. And you also have to remember that it's likely, whether it's medical, clinical, aesthetic, whatever you want to call it, it is likely that the claimant will be one of hundreds, if not thousands, of faces that you've dealt with by the time the claim reaches you. You will probably be their only optometrist or gynecologist or beautician. And so they will have a better memory of events, or certainly that will be the allegation against you if it reaches court. And it's hard to overcome that if you don't have detailed records. And it doesn't have to be an opus, but again, if you use that as an example, something more than consent discussed, 3 or 4 bullet points as to what actually was discussed can save you a lot of aggravation down the line.
What are you finding, or have you come across any cases where less formal types of communication have been used and have resulted in records being generated of clinical discussions on things like WhatsApp and text messages? I've certainly found when I've been handling cases in say, the aesthetic space, people tend to sort of let their guard drop a bit when they're using that kind of communication. And there's an informality about it that does have a tendency to come back and bite you. Unless you're careful, you get it screenshotted and before you know it, it's forming part of a pleading against you.
Saw a case where that exact thing happened. It was an aesthetics case. It was a filler case. I can't remember what part of the body was being filled at this point. It was either the butts or the lips, but it was exactly that situation. The patient, the claimant, had contacted the treatment provider afterwards on WhatsApp, said, I don't like the look of this. I think I might have an infection. What should I do? Well, look, at that point, there's only one correct answer. Go and seek medical advice. The individual wasn't medically trained. Unfortunately, without divulging too much, similar sequence of events to the one you've just mentioned, where there was a back and forth and there was an informality. The fact that I've seen those screenshots and I'm talking about it shows you that they were screenshotted and they will form part of the evidence of that case if it reaches court. You've got to be really careful. And it's perhaps interesting because those in the beauty sector might not have as much professional experience as medics. And you can't imagine, like you said, that ever happening with doctors or nurses, for instance.
Well, actually, I have had cases. I have, yeah. So I wouldn't draw the line just at the aesthetics. So I think there is a movement towards the WhatsApp types of communication, particularly, for example, if you've got someone who's had a surgery maybe on a Friday, it's then out of hours, they've gone home, the surgeons maybe, if you've got any issues, just text me, phone me, whatever. And it does lend an informality and it also lends a shortness. So again, coming back to the record keeping, sometimes wish you'd just added in a few more sentences. That's the temptation, I think, in relation to, WhatsApp and those
and the
kinds.
pressure to respond quickly as well, isn't there?
Yes.
My ultimate red flag was whenever I saw the word hun. That was that was it. Yeah.
Mine's numbers in texts, before that kind of thing. It's a little bit mortifying to have to read that out on behalf of somebody at a trial in their defence, because maybe it's just that I'm a dinosaur. I would accept if that charge was levelled at me. But I personally think a short email perhaps reflects better ultimately when it's being put in the trial bundle.
Yes. I know that you also, whilst we're on the avoiding claims, preventing claims leg of this podcast, that you also think that it's really important to understand the framework that you're working in as a healthcare professional.
I agree. And this comes from my personal injury background as well. So the PL and ClinNeg background, I've often seen documents such as risk assessments. They're undertaken by people who are really doing their best, but they don't understand the purpose of the document or the procedure that they're going through. So that renders the document really just words. It's not actually addressing the issue that it's looking at. Equally, in terms of training staff, it comes back to the point you made before in relation to consistency. Aide memoire forms are brilliant, but the staff really need to understand what they're filling them in for. If they're doing part of the consent procedure, if you're using that process of a consent beyond just one individual, they need to understand what they're filling the consent form in for. So, for example, your Fitzpatrick skin type tests or your care homes in relation to the care plans, do your staff understand how they fit individually into the framework with the district nurses, the TVNs, the GPs, for example? Do they know what triggers the next stage of the process, who they need to call, who's going to be replacing dressings, who's going to be measuring any pressure sores they may have come across or photograph? Is that the district nurse? Is that the TVN? Is that the GP, or is it me? So I think understanding all of that background and where you fit into that system really would help.
Thank you. And I think there's also I would just add to that, certainly in the aesthetic sphere, it's also important to be familiar with what your insurance policy requires you to do. For example, most policies would stipulate that it's a condition precedent to you being covered that you should perform a patch test, or that you should have stringent requirements about the provenance of any products that you're using, or that you should have infection prevention systems in place and so on. And whilst those are all of their own good risk management things that should be done to reduce the likelihood of a claim, it doesn't hurt to emphasize that if you do get a claim made against you, you really need your insurance to be there to stand by you in that and to help you with that. And so a familiarity about what your cover requires is really important.
Yeah, I would say that's the tip. You can't always prevent a claim, but some things do happen. You come across the wrong situation. It's good to have your insurance on side, not just to mean that the claim is met, but that you have us along on the journey with you. What could be better, But in all seriousness, I do think it's important part of our job to lift that burden off people's shoulders and allow them to not to be cowering under the weight of the concern that a claim can bring. I have seen plenty of people over the years who have been really upset and stressed out by claims that have been brought against them. And once the team swings into action, I'm not saying it makes it straightforward, but it certainly helps, I think.
Yeah. And Arya, is there anything else that you would add to that part of the discussion?
To go back to what you said, Will, before about having a one-stop sort of solution for cover across the broad spectrum of claims, as the beauty and aesthetics industry perhaps becomes increasingly diverse with an increasing range of what you might call invasive or complicated treatments, it's clearly going to be important to assail yourself with both an insurer and a legal team who have a range of experience across various different clinical and therapeutic settings.
Yeah, thank you. I'm conscious that we've been going for some time, and thank you both very much for sharing those insights with me. I think if we could wind up maybe with a little bit of horizon scanning, and if I could ask both of you what you see as being the big themes, issues, cases that you see coming down the track. What's the next big thing coming down the track in your world, in ClinNeg world, in the next 6 months or so, 6 to 12 months?
You were talking about the track. I think that was the perfect way of putting it, actually. We've got to mention, haven't we, the intermediate track, which came in on the 1st of October 2023. I think we've probably not all felt the effects of that yet. We've probably swerved it to date, but it is literally coming down the tracks at us, along with the fixed costs. They're due, I think, later on this year, fixed costs in ClinNeg, I think October 2024 for that aspect. So those are some big themes in relation to this sort of area of the ClinNeg world, I would imagine.
They're going to have a pretty fundamental impact on the way that these cases are managed, aren't they?
Yes, I would say the jury's still out. It's like the RTA world, isn't it? It's like whack-a-mole. There's always a way around from both perspectives. So it will be interesting to see how it pans out. But certainly a shift towards the sort of approach that's been taken thus far in RTA claims. So we'll see if it has the same effect. And maybe in 10 years' time, we'll be knocking on the door of housing claims or something along those lines. And people will be complaining of our inexperience. Who knows?
Yeah.
I think some people already are knocking on the door of housing.
Arya, what about you?
Just to pick up on cost issue, in one sense, that distinction we talked about before about knowing whether a claim is a public liability claim or a clinical negligence claim, in one sense, that distinction will become even more important now that the intermediate track is in, because, of course, public liability claims up to 100,000 will, at first glance at least, subject to any argument on complexity, be subject to fixed recoverable costs. That highlights how important that distinction is now. Of course, for the lower value claims in clinical negligence, we have fixed costs coming in from October this year, we think. It's only just been announced, so it may be delayed again. And it's not entirely clear how those will work, but we do know for the time being at least that will be for your lower value claims, not an awful lot of clinical negligence claims which are £25,000 and below. So I think that distinction is still incredibly important. What the reforms in October 24 do tell us is that it's step one, and there is now precedent and an appetite for imposing fixed recoverable costs on clinical negligence claims. So whether we're sat here in 10 years talking about there being any kind of practical difference between any of the types of claims is another thing entirely.
Yeah, thank you. Well, we could talk about these issues for much longer, I fear, but I think we ought to draw it to a close there. It just remains for me to thank you both again for being such good sports and for coming on and for providing your words of wisdom and for being such interesting and informative guests on the AlteaTalks podcast.
Thank you so much for having us.
Thank you for having us, Will.
Thank you for tuning in. I hope you enjoyed today's episode of AlteaTalks. If you did, please don't forget to subscribe or leave a like or a review on whatever platform you're listening on, as this helps spread the word. If you have any questions or comments or topics you'd like us to explore in future episodes, please do contact us, as we'd love to hear from you. You can find us on LinkedIn or visit our website at www.alteainsurance.com. Stay tuned for more episodes, and until next time, take care of yourselves. The information contained in this podcast is not intended to represent a complete analysis of the topics presented and is provided for information purposes only for practitioners based in the UK. It is not intended as legal advice, and no responsibility can be accepted by Altea Insurance, Arya Tabrizi, or Victoria Heyworth, or King's Chambers for any reliance placed upon it. Independent legal advice should always be obtained before applying any information to particular circumstances.